Hello, I'm Chris Rokosh, and this is the first of a four-part video series titled Legal Issues in Nursing, Empowering Nurses with Medical Legal Knowledge. It will be helpful for you to view these videos in order, as each one will build on the information presented in the one before. In this video, you will learn about medical malpractice lawsuits, legal definitions, nursing responsibility, the most likely areas for a lawsuit to occur, and some medical legal trends and issues. Healthcare systems are run by people, and people make mistakes. Adverse events happen, and thousands of patients are injured every year. Medical malpractice exists to protect the patient. It is a way for them to receive financial damages or money for an injury believed to be caused by a member of the healthcare team. Historically, medical malpractice lawsuits involve mostly doctors. But as the role of the nurse gradually shifts to include more responsibility and a broader scope of practice, nurses are increasingly pulled into litigation as well. Let's start with a review of definitions and words that are frequently used when talking about medical malpractice lawsuits. First of all, the word litigation means a lawsuit or the process of suing someone. An adverse event is defined as the unintentional injury, accident, or complications that are caused by errors in healthcare rather than by a patient's underlying disease process. As you likely know, adverse events can lead to serious outcomes for the patient, including injury, disability, prolonged hospital stay, or even death. The word damages refers to the money that may be awarded to a patient if the lawsuit is successful. Allegations are statements that are declared to be true, but must be proven during the course of a lawsuit. The terms negligence and malpractice are frequently used interchangeably, but have slightly different meanings. Malpractice is defined as the improper or unethical conduct or unreasonable lack of skill by a holder of a professional position. This often applies to doctors, dentists, lawyers, and public officers. Malpractice is the word most frequently associated with lawsuits involving doctors, as in medical malpractice lawsuits. Negligence is defined as the failure to use such care as a reasonably prudent and careful person would have used under the same or similar circumstances. Negligence is a word frequently associated with lawsuits involving nurses, as in nursing negligence lawsuits. The standard of care or standard of practice refers to the expected knowledge, skill, and accountability of the nurse. There's an expectation that a nurse caring for a patient will act according to the standards of care or as another reasonable nurse with like training and education would have acted in the same situation. That is why it is so important for all nurses from all clinical areas to know the current nursing standards of practice that apply to their job. Because doctors and nurses work as a team, they are frequently sued together. Here are the three sides typically involved in any nursing negligence or medical malpractice lawsuit. First, there is the patient or the family of the patient who starts the lawsuit, who are known as the plaintiff. Second, the doctor or doctors who the patient believes or alleges has caused them harm will be known as the defendant doctor. The third party is the nurse or nurses, who the patient also believes or alleges has caused or contributed to their harm. They are known as the defendant nurse, and the hospital or institution who employs them will be known as the defendant hospital. It is often helpful for nurses to know that in almost all cases, even though it is the nurse who will be sued and named in the lawsuit, it is the hospital or the healthcare institution where they work that will ultimately pay any damages or money awarded to the patient. The employer is considered responsible to properly staff units, to train and supervise the nurses who work for them. They will also be considered vicariously liable or accountable for the actions of their employees. Your professional association may provide errors and omissions insurance in the event of a lawsuit. Self-employed nurses must assume full responsibility for any damages, so they may be required to purchase their own insurance. It may also be helpful for you to know that lawsuits are typically separate and apart from any disciplinary action by nursing, regulatory, or licensing bodies. The expected outcomes of these two investigations are different. Because medical malpractice exists to protect the patient, the expected outcome of a successful lawsuit is the patient or plaintiff will receive damages or money because they suffered an injury. On the other hand, nursing regulatory bodies exist to serve and protect the public, regulate nursing practice, and promote and support safe nursing care. The expected outcome of a complaint to a regulatory body is that the nurse will be investigated and corrective action will be taken where necessary. The nurse may be disciplined, required to undertake further education, be asked to practice under supervision, or in some cases, lose their nursing license. In many countries around the world, nursing practice is defined, regulated, and governed. The nursing profession is overseen at both the national and local levels to support safe patient care. It is considered a basic nursing responsibility to provide safe, competent, and ethical care at all times and in all situations. Each nurse also has a personal responsibility to ensure that their own practice and conduct meets these guidelines. The legal system also has a perspective on nursing responsibility. It is that the nurse must provide care which is reasonable under the circumstances. The premise behind all nursing negligence lawsuits is that the nurse failed in some way to act as another reasonably competent nurse would have acted in that same situation, and that their failure caused or contributed to an injury to the patient. In nursing negligence lawsuits, it's important to determine the standard of care, as in what should the nurse have done in this situation, and then to identify which member of the healthcare team was responsible for the injury. For instance, in a case involving a post-operative infection on a surgical unit, the nurse may be held responsible for failing to monitor vital signs or failing to communicate to the doctor or charge nurse that the patient had a warm and reddened incision. These tasks fall within the nursing duty and scope of practice. The doctor, on the other hand, may be held responsible for failing to prescribe the appropriate antibiotics or failing to order lab testing that might have confirmed the infection. These tasks fall within the medical scope of practice. The most frequently sued clinical areas in healthcare are obstetrics, the emergency room, and medical surgical units. But every area of nursing practice can be affected, and no nurse is immune to litigation. Although the number of malpractice suits has trended downwards over the past years, the amount of damages awarded to the patient has increased significantly. There is speculation that many adverse events go unreported and that nearly 40% of the injuries that occur to patients were fully preventable. By learning more about litigation realities, nursing responsibility, and the standards of care, you are taking proactive measures to protect your patients from harm as well as to protect yourself from a lawsuit. And it will be helpful for you to be familiar with legal terminology in order to gain a better understanding of what to expect if you are ever involved in one.